My father-in-law called me into his office on a Monday morning, gestured for me to sit down the way you'd invite a vendor in for a brief, unpleasant meeting, and told me that the company was restructuring and that my position was, unfortunately, being eliminated effective immediately. He said it the way you'd deliver ordinary news about the weather. 15 years of work, reduced to a single word. Restructuring. I sat across from his enormous mahogany desk, in the same chair I'd sat in 100 times before, and I asked him, quite calmly, whether he understood what would happen to the company's core product line the moment I walked out that door. He told me not to be dramatic. He told me the company would manage fine without me, the way it always had. What he did not know, what he had apparently never bothered to fully understand in 15 years of treating me as replaceable staff, was that the patent behind that core product line, the one generating nearly all of the company's revenue, was registered in my name alone. My name is Perdita Holloway. My father-in-law's name is Augustine Holloway, founder and, until recently, chairman of Holloway Precision Instruments. And this is the story of the day he fired his own daughter-in-law without once checking whose signature actually controlled the thing his entire company was built on. I met my husband, Thaddeus Holloway, 16 years ago in graduate school, where we were both pursuing degrees in mechanical engineering at a university 2 states from either of our families. Thaddeus was warm and a little scattered, brilliant in the specific, unglamorous way that shows up more in careful problem-solving than in flashy presentation, and I fell for him slowly, over long nights in the engineering lab, working alongside each other on separate projects that occasionally, quietly, became a shared one. Thaddeus's father, Augustine Holloway, had built Holloway Precision Instruments over nearly 4 decades, starting as a small machine shop producing custom parts for the local manufacturing industry and gradually expanding it into a respected, mid-sized company specializing in precision measurement instruments used across aerospace, medical device manufacturing, and industrial engineering. Augustine was, by every account, a genuinely talented engineer in his own right during the company's early decades, though by the time I entered the family, his role had shifted almost entirely toward the business and leadership side, with the actual technical innovation increasingly handled by a team of engineers he employed, including, eventually, both his son and, after Thaddeus and I married, me. I want to describe Augustine honestly, because I don't think this story is served by making him a simple villain. He was, in many ways, a genuinely accomplished man, fiercely proud of what he'd built, and generous in certain concrete ways. He paid his employees fairly. He'd kept the company afloat through several difficult economic stretches without laying off long-term staff. He genuinely cared about the quality of the instruments his company produced. What he struggled with consistently, throughout the 15 years I knew him, was a deeply ingrained assumption about who, within his own family and company, was capable of genuine technical brilliance, and who was simply useful support around the edges of it. Thaddeus, as his only son, occupied the first category in his father's mind, automatically, from birth, regardless of the actual evidence of his day-to-day work. I, as the daughter-in-law who had married in, occupied the second category just as automatically, regardless of the fact that I held the same graduate degree as Thaddeus, from the same respected program, and had, if anything, consistently outperformed him in our shared coursework. Thaddeus and I both joined Holloway Precision Instruments shortly after we married, 13 years ago, at Augustine's invitation, eager, at the time, to build our careers within a family business that seemed to offer stability and genuine engineering work rather than the more corporate, less hands-on positions we'd both been considering elsewhere. I want to be honest that I entered this arrangement with real enthusiasm, genuinely excited to contribute to a company with a strong technical reputation, and genuinely hopeful, in those early years, that my work would eventually earn the same respect Thaddeus received almost automatically. For the first several years, I worked primarily as part of the company's research and development team, under a talented but overworked lead engineer named Cordwainer Ashby, who, to his credit, recognized my technical abilities immediately and gave me increasingly significant responsibility on several of the company's core projects. It was during this period, working late into countless evenings, that I began developing what would eventually become the company's most significant technical breakthrough in over a decade. A novel calibration mechanism for precision measurement instruments that dramatically improved accuracy while reducing the manufacturing cost of the company's flagship product line. I want to explain the technical details only enough to convey their significance, without losing the human thread of this story. The core innovation involved a specific mechanical and electronic calibration approach I developed largely independently, working through countless late-night iterations in the company's lab, refining a concept that had originated, honestly, from a stray idea I'd had during my own graduate research, one I'd continued privately developing even after joining the company. When I finally brought a working prototype to Cordwainer, he was, genuinely and immediately, thrilled, recognizing right away that this innovation could reshape the company's entire product line. Here is the detail that would eventually matter more than almost anything else in this story. When Cordwainer and I brought the prototype to Augustine for formal development approval, the question of patent filing came up, as it necessarily does with any genuinely novel technical innovation intended for commercial production. Company policy, at the time, generally assigned patent ownership to Holloway Precision Instruments itself for any innovation developed using company resources and company time, a standard, reasonable arrangement that most employees, including myself, would have accepted without much thought in most circumstances. But this particular innovation had a complicated origin, one that Augustine, in his eagerness to move quickly toward commercialization, never fully investigated at the time, though I made sure, deliberately, that it was properly documented. The core conceptual breakthrough, the specific calibration approach at the innovation's heart, had originated during my graduate work, before I ever joined the company, developed on my own time using my own resources, years before Holloway Precision Instruments had any claim to it. What I had done at the company was refine, engineer, and productize that original concept into something commercially viable, real, and significant work, but built on a foundation that predated my employment entirely. I consulted, quietly and carefully, with an intellectual property attorney named Winifred Castellane before finalizing the patent filing, wanting to understand exactly how this complicated origin affected ownership. Winifred confirmed what I had begun to suspect. Given the documented timeline of the concept's original development, predating my employment, I had a legitimate, defensible claim to personal ownership of the foundational patent. Even though the company could reasonably claim ownership of certain specific engineering refinements developed afterward using company resources. I made a decision at that point that I want to explain honestly, because I don't think it reflects any grand scheme or premeditated plan for the eventual confrontation this story leads to. I decided, on Winifred's advice, to file the foundational patent in my own name, personally, while separately licensing its use to Holloway Precision Instruments through a formal licensing agreement, one that granted the company exclusive commercial rights to manufacture and sell products using the innovation, in exchange for a modest ongoing royalty structured into my compensation. I did not do this to secretly gain leverage over the family business, or to protect myself against some future betrayal I couldn't have anticipated at the time. I did it, honestly, because Winifred's advice made clear that this was simply the legally correct way to handle an innovation with this particular documented history, and because, if I'm being fully honest, some quiet, cautious part of me, even then, understood that I occupied a precarious position within a family company that had never fully trusted my technical judgment the way it trusted Thaddeus's, and some instinct told me it would be wise to protect my own interests properly rather than simply trusting that fair treatment would follow naturally from good work. Augustine, when the licensing arrangement was explained to him at the time, by both Winifred and Cordwainer, agreed to it without significant objection, primarily, I believe, because he was eager to move the product into development quickly and didn't want a drawn-out ownership dispute to delay the company's access to what was clearly a significant commercial opportunity. I don't think he fully absorbed, at the time, the actual long-term significance of what he was agreeing to. He signed the licensing agreement and the product line, Eventually branded as the Holloway Precision Calibration Series, launched 3 years later to significant commercial success, quickly becoming the company's single largest revenue generator, eventually accounting for well over half of the company's total annual sales. For the following decade, this arrangement functioned quietly and largely without incident. I continued working at the company, contributing to numerous other projects alongside the ongoing royalty income from the calibration patent, income that was folded, administratively, into my regular compensation structure in a way that, I suspect, most people at the company, including Augustine himself over time, gradually stopped thinking about as anything separate or significant. I had become, in the company's day-to-day culture, simply Thaddeus's wife who works in R&D, a framing that persisted despite my substantial technical contributions, despite years of solid, well-regarded engineering work across multiple product lines, despite, apparently, even the fact that I held personal ownership of the intellectual property underlying the company's most successful product. The dynamic between Augustine and me grew more strained over the years for reasons that had little to do with the patent itself and much more to do with the accumulated weight of 15 years of being quietly underestimated. Augustine promoted Thaddeus to a senior engineering leadership role 8 years into our tenure at the company, a promotion I genuinely believed Thaddeus had earned through solid, consistent work, though I couldn't help noticing that my own, arguably more significant technical contributions during that same period never resulted in a comparable advancement. When I raised this, carefully, in a private conversation with Augustine about 5 years ago, he responded with the kind of dismissive, if not unkind, certainty that had characterized most of our interactions over the years. You're doing important work. Perdita, don't misunderstand me. But Thaddeus has the vision for where this company needs to go. That's simply a different kind of contribution. I did not push the issue further at the time, partly out of exhaustion with a battle I'd fought quietly for years without much progress, and partly, I'll admit, out of a lingering hope that continued excellent work would eventually shift his perception, even if direct advocacy for myself hadn't managed to. The final rupture came 18 months ago, when Augustine, increasingly focused on succession planning as he approached his early 70s, decided to restructure the company's leadership team ahead of an eventual transition of control to Thaddeus. This restructuring, I want to be clear, was not inherently unreasonable. Planning for leadership succession is a normal, necessary part of running a family business. What made it painful, in my particular case, was the specific decision Augustine made regarding my own role within that restructuring. He called me into his office on a Monday morning in early spring and informed me, in the brisk, business-like tone he reserved for personnel matters, that as part of the company's broader restructuring ahead of Thaddeus's eventual full leadership transition, my position within the R&D department was being eliminated. He framed it, carefully, as a streamlining decision rather than a personal one, explaining that the department's structure was being consolidated under a new external hire, a younger engineer he'd recently recruited from a competing firm. Someone he described, with what felt like a pointed emphasis, as bringing fresh perspective and genuine innovative vision to the team. I sat across from his desk, absorbing this news, and I asked him, as calmly as I could manage, whether he had fully considered the implications of eliminating my position, given my ongoing role in the company's technical operations. Perdita, he said, in a tone that carried a familiar, weary patience, the tone of a man explaining something he considered obvious to someone he didn't expect to fully grasp it. I understand this feels personal. But the company needs to move forward with a clearer, more streamlined leadership structure. You've done fine work here over the years, genuinely, but the company will manage fine without you. It always has. I want to describe what I felt in that moment honestly, because I think it matters more than any clever response I might have delivered immediately. I felt, first and most acutely, a deep, exhausted grief, the particular grief of finally hearing confirmed, plainly and without disguise, an assessment of my worth that I had suspected, on some level, for 15 years, but had never had spoken to me quite so directly. Underneath that grief, though slower to surface, was something calmer and more clarifying, the recognition that Augustine, in that single dismissive sentence, had revealed exactly how little he actually understood about the technical foundation his own company's success rested on. "Augustine," I said, keeping my voice level, "I want to make sure you understand something before this decision becomes final. The calibration patent behind the precision calibration series, the one generating more than half the company's annual revenue, is registered in my name personally, not the company's. It has been since the product's original development, structured through a formal licensing agreement you yourself signed 13 years ago. If my employment ends, that arrangement doesn't automatically continue under the same terms. I'd strongly recommend having legal counsel review the actual licensing agreement before finalizing anything today." I watched something shift across Augustine's face, a slow, uncomfortable dawning that I recognized, having watched similar expressions cross the faces of people confronting a fact they'd allowed themselves to forget or minimize over many years. He did not fully believe me at first, I think, or perhaps simply didn't want to, because he told me, somewhat stiffly, that he'd have the company's legal team look into it, in a tone that suggested he expected this to be a minor technicality rather than the significant complication it actually was. I did not hear from him again for nearly a week, during which time, I later learned, the company's general counsel, a careful, thorough attorney named Bartholomew Quince, had pulled and reviewed the original licensing agreement, confirming exactly what I had told Augustine directly. The patent was mine, personally. The licensing agreement's exclusive commercial rights were explicitly tied to my continued employment and good standing with the company, with a clear provision that termination of my employment for reasons other than serious misconduct would trigger a mandatory renegotiation of licensing terms that, under the original agreement's language, could result in significantly higher royalty rates or, if renegotiation failed, potential termination of the company's exclusive rights entirely. Augustine called me back into his office the following Monday, a full week after our original conversation, and I want to describe the shift in his demeanor honestly, because it was genuinely significant. The brisk, dismissive confidence from the previous week had been replaced by something more careful, more visibly uncertain, the demeanor of a man who had spent a week absorbing an uncomfortable recalibration of his own understanding. "I had Bartholomew review the licensing agreement," he said, without much preamble. "You were right. I hadn't fully appreciated how the termination provisions were structured. I'd like to discuss how we move forward from here. I want to be honest about what I felt in that moment, because I think it matters more than a simple narrative of triumphant vindication would suggest. I did not feel purely satisfied or purely vindicated. I felt, mostly, a kind of tired sadness that it had taken a legal complication, rather than 15 years of genuine, consistent work, to finally produce this shift in how Augustine was willing to engage with me. "I don't want to renegotiate out of leverage, Augustine," I told him honestly. "I want to understand something first. You've known, technically, for 13 years, that this patent was mine. You signed the agreement yourself. And yet you sat across from me last Monday and told me, without a second thought, that the company would manage fine without me, as though my contributions here had never amounted to much of anything. I need to understand how those two things exist in your mind at the same time before we talk about licensing terms." He was quiet for a long moment, and when he finally spoke, his voice carried something I had genuinely never heard from him before, in 15 years of knowing him, something that sounded, unmistakably, like real shame. "I think," he said slowly, "that somewhere over the years, I stopped actually seeing the patent as connected to you personally. It became just another piece of company infrastructure in my mind, like a piece of machinery, separate from the person who created it. I think that happened, if I'm honest with myself, because it was easier than reckoning with the fact that some of my company's most important work came from someone I'd never quite been willing to see as an equal to my own son, technically speaking. That's not fair to you, Perdita. It was never fair, and I let it go on for far too long because acknowledging it would have meant admitting I'd misjudged you badly for a very long time. It was not a perfect reckoning, delivered all at once and completely, the way these things rarely are in real life. But it was, I think, the most honest thing Augustine had said to me in 15 years, and I found that I valued the honesty considerably more than I might have valued a more polished, less costly apology. We spent the following weeks working through a genuinely fair resolution, with Bartholomew and Winifred both involved to ensure the process was handled properly on both sides. I did not choose to leave the company in the end, though I understood I could have, and though the leverage the situation had revealed would have supported a clean, well-compensated departure if that's what I'd wanted. What I chose instead, after real reflection, was to stay, but on fundamentally renegotiated terms, a formal leadership position on the company's technical advisory board, with real decision-making authority over future product development, and a restructured licensing agreement that reflected, finally, the actual value of the work I had been quietly contributing for over a decade. Thaddeus, when he learned the full scope of what had happened, was genuinely angry on my behalf, angrier, in some ways, than I had allowed myself to be in the moment itself. 15 years, he said, more than once, in the weeks that followed, and he never once actually understood what you'd built. I told him, honestly, that I thought part of what needed to change wasn't just his father's understanding, but the pattern within their own marriage and family life that had allowed this dynamic to persist so long without either of us directly confronting it. Thaddeus, to his credit, took that observation seriously, and it began a longer, more difficult conversation between the two of us about the ways his own comfortable position within the family business had, unintentionally, made it easier for both of us to avoid pushing back against his father's assumptions for years. Augustine retired fully from active company leadership about 8 months after that confrontation, transitioning control, as originally planned, to Thaddeus, though now with me serving in a genuine, formally recognized leadership capacity alongside him rather than the quietly underestimated position I'd occupied for the previous decade and a half. Augustine and I have, since then, built something that resembles genuine mutual respect, still occasionally awkward, still carrying the residue of 15 years of accumulated misjudgment, but real in a way it had never quite managed to be before. I think about that Monday morning often, more than I think about the eventual resolution, if I'm honest. Because the resolution was simply the natural consequence of a legal structure I had, wisely, put in place years earlier, almost as a quiet act of self-protection I hadn't fully understood I would one day need. The real story, the one that matters most to me, is that it took a legal document, rather than years of genuinely excellent work, to finally force a reckoning with an assumption that had shaped how I was treated for a decade and a half. If someone spent 15 years treating your work as replaceable, easily discarded, secondary to someone else's presumed brilliance, and then discovered, suddenly and undeniably, exactly how much their entire operation actually depended on you, what would you have done? Would you have simply walked away, vindicated but finished with them entirely? Or would you have done what I did, and stayed, insisting, finally, on being seen clearly for exactly what you had always actually been?